Hello, my name is Harold Furchtgott-Roth with the Center for the Economics of the Internet here at the Hudson Institute. It's our great honor today to welcome Commissioner Noah Phillips of the Federal Trade Commission to the Hudson Institute to discuss recent developments at the FTC. Commissioner Phillips, as we all know, has had a long and distinguished career, both in the private sector and in government, and he's now one of the 5 commissioners at the Federal Trade Commission. Commissioner Phillips, welcome to the Hudson Institute.
Thank you, Harold, for having me. It's great to be back here at Hudson and with you in particular.
Well, thank you. Tell us a bit about a recent commission decision on prior notification in Hart-Scott-Rodino that was decided at an open meeting of the FTC back in July. Tell us the background about Hart-Scott-Rodino and what the commission did.
Sure. And I should have mentioned a moment ago, just the standard caveat that I have to give, which is my remarks are just my own, not necessarily the views of the commission or my fellow commissioners. So, especially for your audience who are not close followers of antitrust law or merger policy, Hart-Scott-Rodino refers to the law that we've had on the books in the United States since 1976 that allows the government to look at big mergers before they happen. It gives the government a chance in advance. And that's important because of what the world looked like from 1890, and especially from 1914, where our Merger Statute Clayton Act was passed, until 1976. That was a world where the government had to go in and undo problematic mergers after the fact. And it was a mess. It was bad for businesses, because they would make plans and they would make investments and they would integrate businesses. And then after a court order or what have you, they would have to unwind them. And that can be very disruptive. But it was also really bad for the government, for antitrust enforcers, for 2 reasons. The first was that they didn't have the ability to see the mergers before they happened. And they had to deal with skeptical courts. And the second was, and this is also why it was bad for the public, is that the harms from those mergers would start happening before the government had an opportunity to go in. So this was a messy process. The government wasn't effective. The judges were skeptical and loath to break up companies after the fact. And what you got out of Congress, this is during the Ford administration, was really what I call a win-win for the public, for regulators, for companies. We get notice of deals in advance, and we get a chance to deal with them in advance. And while companies have to spend the time in investigation and may have to spend the time in litigation, we more often than not get to resolve matters before longer-term investments are made. Not only for those companies, but for others doing business with them. So Hart-Scott-Rodino made merger enforcement more effective, it protected consumers better, and it gave businesses the ability to invest capital with a reasonable amount of assurance of how the future looked. So this is, again, a win-win. Not so long after Hart-Scott-Rodino, let me back up for a moment. Before the statute was passed, one of the things that the government would do in court or in negotiated consents with parties is it would try to get advance notice of future mergers. And it would try to get the right as a government agency to pre-approve the merger. So right now the burden is on the government to show that the law has been broken. But for these particular cases, the government wanted the ability to say yes or no without a court decision. But after Hart-Scott-Rodino, the rationale for the first bucket, prior notice, to a large extent went away. There are still some mergers that don't come through Hart-Scott-Rodino, and sometimes we go after them because they're anti-competitive. But in the main, because of the statute, the government got this advanced look that it had been trying to recreate or create for itself out of a combination of court orders through consents. And sometimes the government would see or have reason to believe that you would have the same merger. Companies would try to do the same thing in the future, and that might be problematic. And in the 90s, this was rationalized. The FTC put out a policy for when it would seek these provisions in consent with parties that wanted to merge. And just so your audience understands, what a consent is, consistent with the scheme of Hart-Scott-Rodino, sometimes the government is going to let a merger happen. That's generally what happens. Sometimes the government will have to block it outright. But many times, and again, this was the congressional scheme, the government will want to work out the problem. And there are times where, let's say, we're looking at a bunch of gas stations that are being acquired, and in 10% of the areas, they're problematic. We may just want to do it the vestige. Like we may just want to allow the company to sell off the non-problematic assets, or excuse me, the problematic assets, and let the rest of the market function. And that's been the policy that was what Congress had in mind with Hart-Scott-Rodino. What we did a few weeks ago is we took down the guidance to the market of when we would seek these provisions, when we would say, we're only going to allow part of your deal if you allow us to, allow us the right to decide whether you merge without a court order later. And my worry here is the following. What this effectively does is it taxes working with the government to resolve mergers at the beginning. And I think that's a problem, because I think we want parties to come in and work with us to try to sort out the problematic aspects, and we want to let the rest of the market operate. I also think one of the perverse effects that this is going to have is that the people most likely to agree or most likely to be hurt by this are the smaller parties merging, whereas the bigger parties may just fight or will be more likely to fight because they have more resources. And that to me is a sort of perverse effect. All of this links up with a number of steps that I think you've seen out of the agency lately that make me really worried about the integrity of the Hart-Scott-Rodino process. So for example, I can't remember, it was late January, early February, we announced the end of the early termination program. Early termination, under Hart-Scott-Rodino, when you submit your proposal for a transaction, you can't close for 30 days. And traditionally what has happened for stuff that the government isn't interested in at all, think about it like an executive that gets stock in his company, or mutual funds or large asset managers that buy more funds so that their ETFs can continue to track the S&P or something like that. There are a lot of,
Sure.
When you see news about merger filings, some of those filings are colloquially mergers, many of them are not. So historically, parties have been able to come to the agencies and say, you're not interested in this, can we just go ahead and finish our deal? And the agencies have said yes. And now what the agencies are saying is no. So what we're introducing is an inefficiency in the market for transactions that we have no interest in pursuing, just for the sake of the thing. I think that's a problem. I think it makes us less efficient. I think that requiring, in all cases, we'll see whether we succeed, but advance notice and advance approval, I think that's going to introduce inefficiency into our process. There have been press reports that we're sending letters to companies saying, don't close your merger when we're not investigating. If that's true, that introduces inefficiency. The executive order that the president issued a few weeks ago encourages us to bust up more mergers that are consummated. I think if we have reason to believe that they're causing a problem, that's something we do typically for stuff where parties have had the benefit of repose, and busting them up, I think that creates a problem. There are other reports, some of which involve the FTC, others DOJ, where we're simply not making decisions. There is also press reporting that we at the FTC are not making decisions as quickly as the DOJ is. All of this is just introducing inefficiency in the merger process. And my concern is that it is making merger enforcement less effective, less efficient, and less fair. And I don't know why we want to do that.
Commissioner, the prior policy had been in place for the past more than a quarter of a century. Was there a sense that it wasn't working well? And were there lots of academic articles saying this isn't working well, it needs to be changed? Was there a lot of speeches on Capitol Hill from politicians saying it's not working well. Was there a general sense that it wasn't working?
With respect to prior approval and prior notice, that I'm not aware of. I think you see some voices on the Hill, and you saw this last spring, who simply think that all mergers are bad. Right? There were proposals at the beginning of the pandemic, Congressman Cicilline, Senator Warren, Congressman Ocasio-Cortez, to ban all M&A activity. And I think if that's the frame, then yes, there are voices calling to end the policy. But I don't think that's what most people believe. I don't think that's what Hart-Scott-Rodino envisions. And certainly with respect to that prior approval, prior notice of policy, I had not seen that evidence.
Tell us a bit more about President Biden's executive order on competition. What does it say? And as a commissioner of an independent agency, are you bound by an executive order?
So the position of the agency has long been that we are not. And the order does respect that fact. I mean, it does a lot of, I don't have the wording right in front of me, but encouragement.
Yeah.
That kind of thing.
Right.
But I do think it provides a sort of executive direction to the agency. There are certain things, the order is cast as a broad look across the government to encourage competition. And competition is good. And there are aspects of the order that I think are also good. I think the order is right to raise concerns, for instance, about occupational licensing. You see regulations at the state level, essentially state-sponsored cartel behavior that keep people from getting new jobs, from starting businesses.
Right.
And that can be a real problem. And I was really pleased to see that it will continue its efforts in that area, which has been a bipartisan thing for a long time. But there are other aspects of the order that are problematic for me in two ways. One is that I do think in many respects, what it envisions is not the encouragement of competition, but the adoption across the board of new regulation. The theory of the thing is that these new regulations will stoke competition, and there are regulations that can. But a lot of times regulations have the opposite effect. They chill competition, they prevent market forces from working. The second thing that I have an issue with is I think to some extent the order is based on the presumption that the FTC in particular has a lot of regulatory authority to make competition rules. And that doesn't jump out at me from looking at our statute. I don't think we have that authority. So the order contemplates us making rules in tech and devices and labor and pharmaceuticals. And that's a pretty broad claim about the power of an agency, that we have the authority to regulate so much of the economy. And I think that's a problematic thing.
The FTC has a long history going back over 100 years. And during that time, has the commission promulgated rules on antitrust, I'll put it that way, as opposed to guidance?
So we did once. In 1968, we did a rule governing the relationship between manufacturers and retailers of men's and boys' tailored clothing. There is a law on the books from the 30s called the Robinson-Patman Act about retail, in particular grocers more generally, and to some extent this rule tracked that. There were concerns by some retailers of men's and boys' tailored clothing that they were being discriminated against by the manufacturers. So the rule was adopted in '68. We didn't do anything with it. We never brought a case under the rule. And in the Clinton administration, they pulled it down. But other than that, the agency has never made a competition rule. And in fact, from 1915, when we started as an agency, until the 60s, no one even thought we had the authority to do it. For 50 years, half a century, the agency didn't believe it had what administrative law scholars call legislative rulemaking authority. We thought the line in the statute said we can make rules for how we do our work, how we do compulsory process and run our administrative court, this kind of thing. But in the 1960s, the agency discovered that it had this power. And there is one case from the early 70s. This is a Skelly Wright opinion from the DC Circuit that says we have this power. I'm not sure that's going to hold up. Doesn't jump out of the statute, but it is, if it exists, it is a tremendous grant of effectively legislative authority from the Congress to an agency that really nobody talked about, and that seems odd to me.
So for the past more than 100 years, rather than having rules, generally, the commission has operated with sort of a common law precedent and antitrust guidance on various very specific issues. Can you discuss what the commission has been doing and how that's worked over time?
Sure. And this isn't just the commission. From the Sherman Act and the which was enforced by
DOJ as well, right?
Through to the commission, antitrust has, with that one exception, which was never used, that I mentioned a moment ago, been governed by case law and the development through judicial precedent, like many other bodies of law, of standards and based on fact-intensive examination cases. Now, the case law has developed over time to include per se rules, judicial rules, conduct that is so clearly anti-competitive that we can ban it without doing a deep look, without looking at the justifications. That's for things like market division and price fixing that have no real good justification and that we know are going to be mostly bad. But for other areas of conduct, in general, it's been what we call the rule of reason, where you look at the harms, and you also think about what are the justifications for this conduct. Now, it's interesting, in the last couple months, we've seen some language from courts on attempts that the agencies have made and private plaintiffs have made to carve out an area pretty close to per se illegality. We call it quick look, inherently suspect. In the 1-800-CONTACTS case, that's an FTC case. And in the Supreme Court's recent decision in the NCAA case, which goes the other way, courts have been pretty clear that unless you have a really good reason for it, they don't like judicially created rules. And I do think this raises an interesting question. If the antitrust law, on which the courts have the final say, not us, if the antitrust law doesn't, in the main, adopt rules, why is it okay for an agency to do?
You've described how the FTC is starting to look at possibly coming up with rules for antitrust. Is there a parallel effort over at the Antitrust Division of the Department of Justice?
The short answer is no. They don't have, again, I don't think we have this power, but they don't even believe they have this power.
So how would that work if one antitrust agency operates with a set of rules and another federal antitrust agency operates in a very different way?
Right, and then add on to it that the courts are generally
and the courts are the ultimate arbiter of what goes.
I don't know the answer to that question, and I've seen a lot of, including in the president's executive order, rhetoric in favor of rules and next to no consideration of what it would mean for two different agencies to share jurisdiction and one of those agencies to claim and implement a rulemaking power while the other cannot. To be clear, while the agencies generally do agree on antitrust, they don't always. And so this could make that mess even messier. Now, to be clear, our statutes are not the same. So the FTC enforces the Clayton Act and the FTC Act. So outside of the context of Clayton mergers and other related conduct, we have the ability to prescribe unfair methods of competition, which is generally been viewed as similar to the Sherman Act. And there's been a long academic discussion, and there was some debate in Congress back in 1914 about to what extent the unfair methods of competition goes outside of the Sherman Act. And there was a policy adopted in the Obama administration to say when, the agency sort of explained what its standards were going to be. But that was pulled down recently on July 1st, that bipartisan statement. And so it will be interesting to see what the FTC does and how far outside of the Sherman Act, it feels its jurisdiction reaches.
What is the current status of merger guidelines and other guidelines that have been issued by the antitrust agencies over the past several decades?
So the agencies have issued guidelines over the past several decades, as you noted. We've had the latest set of horizontal merger guidelines in place since 2010. And we've had vertical merger guidelines for the last few years that we did with DOJ. That happened under the Trump administration. The president's executive order calls for the agencies to reconsider those guidelines. And I think within hours of the executive order's announcement, the chair of the FTC and the acting assistant attorney general for the antitrust division indicated we would be reviewing our merger guidelines. I have no problem reviewing guidelines. I don't think guidelines are not written in stone. I think parties are entitled to rely on them until we pull them down. But my hope is that as we proceed, what we do is we base our new guidance on, that it have an empirical basis, that it reflect where the economics are, where the law is, and where the agency experience is. That to me is very important.
This all seems a little unsettled if, on the one hand, the FTC may be trying to come up with rules that's a very different paradigm from having guidelines. And then at some point, the courts would have to rule on whether those new rules are permissible or not. And at the same time, there's some cloud of doubt about the guidelines. All of this seems very unsettled, or am I missing something here?
No, I don't think you're missing something. I think what we've seen in the last few months is, the prior approval policy that you started with, the unfair methods of competition statement from the Obama administration, this signal followed by statements in the executive order and from leadership of the agencies to pull down the merger guidelines or evaluate them. We have a lot of taking down the old and not a lot of guidance as to what the new will entail. And that is the ultimate question, right? What is the policy going to be and what is the basis for that policy?
Part of the president's executive order focused on high tech, and there are some people who've spoken or written about having antitrust law applying different ways to different sectors of the economy, whether it's high tech or pharmaceuticals or national security. Do you think there should be specific considerations in different sectors for antitrust, or should everyone get treated exactly the same?
The antitrust rules are rules of general applicability. Congress has, from time to time, adopted specific rules in specific industries. There's a recent example where Congress legislated to make sure that generics can get access to inputs that they need for certain kinds of drug processes that are kind of carefully guarded for their safety. And that's important. So Congress can do that, but I think the critical point here is that Congress can do it. The other thing that I think is important is that whether it's Congress or the agencies, we're tailoring solutions to specific problems. We're not allowing broad policy where the world doesn't look like the anecdote. I think that's important too.
Let's move on to administrative processes at the FTC. And I understand there's a slight variation on the APA for some type of rules at the commission. Can you tell us a bit about that?
Sure. So just to come back to the history that I mentioned earlier. So from 1915 to at some point in the 60s, I'm not exactly sure when, the agency doesn't believe that it has legislative rulemaking power. We don't believe that we are a regulator. But the agency discovers this power in the statute. And in the 60s and 70s, the agency uses this power overwhelmingly on the protection side of acts and practices. And I think most people believe that the agency kind of gets carried away with this. So for example, the Washington Post called us the national nanny when we were thinking about rules that would ban advertising to children. And this results in the closure of the agency. I think it's actually the first government shutdown in American history was the FTC alone. Congress was very dissatisfied. And following the shutdown of the agency and all the agency had to do to promise Congress it wouldn't do what it had been doing, it wouldn't go so far out on a limb, Congress passed a law governing how we made consumer protection rules under our unfair and deceptive acts and practices authority. That's different from the antitrust side of the house that we were talking about earlier. And those rules basically require more process, more notice to the public, more involvement of Congress, this sort of thing, in order to do rules under that broad authority. So Congress said, okay, fine, you have that authority on the consumer protection side, but you have to use it in a more measured way because it is so broad, right? Unfair and deceptive are broad words by nature. There are certain areas where we do have APA rulemaking authority, but those are specifically provided for in statute. So this is what we call the MAG-MOS or Magnuson-Moss procedures. And you've heard a lot of talk, and we do use them from time to time. You've heard a lot of talk from the agency, and you see some reflected in the executive order about rules we could make. But it does require more of a process, and I think that's a fundamentally good thing.
At the end of last year, the Supreme Court heard a case involving sort of an obscure section of the Federal Trade Communications Act, the Section 13B. Can you tell us a bit about that case and what the Supreme Court decided and what the FTC is doing in response to that?
Sure. So I think a little history is probably useful. As part of the same, broadly speaking, suite of statutes that we were talking about a moment ago, Congress was thinking about how to give the agency, how to improve the agency, how to give it authority to go after some different kinds of bad acts. And one of the provisions that it adopted was Section 13B, which the statute said allowed us to go into court and get an injunction, stop bad acts, while our administrative process was ongoing. So we have an internal administrative court. We can use it for antitrust. We can use it for consumer protection, and we do. But 13B allowed us to go to federal court and get an injunction to stop the bad acts. Beginning in the 1980s, the commission realized that it was facing a problem. And the problem was for some of, in particular, the fraudsters. We wanted to be able to get consumers their money back, right? People's money had effectively been stolen. And so the agency started going to court and trying to put in place a receiver to make sure the money wasn't dissipated, and eventually using that authority to get money back to consumers. And from the early 80s, when this program started under Section 13B, through last year, generally courts bless this. I think 8 different appellate courts recognize that not only could we get an injunction, but we could get money, and we could return that money to consumers. But the statute said injunction. And so in the last few years, I think it was a concurring opinion, maybe a dissenting opinion in the Ninth Circuit, but the Seventh Circuit certainly looked at our statute and said, wait a minute, that just says injunction. It doesn't say money. And other parts of your statute do say money. We have another part, Section 19, that allows us to go through the administrative process. And then if the conduct happens in the last 3 years, and it's the kind of conduct that a reasonable person would know is dishonest, we can go and we can get back money that consumers have lost. And the court looked at it and said, this part of the statute says you can get money, but 13B does not say that. And you can't. And now we're in this position where it is more difficult for us to get money back for consumers. And that's why the commission has been calling for Congress to fix it. There's some differences in how we think Congress ought to fix it. But this is very much a live discussion on Capitol Hill right now.
Any sense of whether there's going to be legislation related to this issue coming up anytime soon? Or
you know, I spent 7 years on the Hill, so I've learned not to prognosticate on what will happen. But I do think there's a lot of congressional interest. I think you've got Republicans and Democrats alike working hard on the issue. Again, some differences into exactly how to write it. But my view is that we should have some guardrails on the authority. But I do think it is important, and something you've heard from members of Congress, I absolutely agree with this, where people have their money stolen from fraudsters, we should have an efficient way to get that money back to those people. I think that's an important thing.
For years, if the FTC launched a formal investigation of a company, is a very, very serious matter. Can you tell us about whether those investigations used to require a vote of the full commission, and whether that has changed recently?
Sure. So under the statute, authority to issue compulsory process, subpoenas for documents, for information, for testimony, has been with the commission. There were certain areas, in particular on the consumer protection side, where the commission had essentially deputized staff, or with the assent of one commissioner, to go out and get compulsory process. And that made sense because there were a lot of these things. It was wasting commission time and it wasn't going to be efficient. But what you've seen, you saw it at one of our public meetings, we adopted some omnibus resolutions that for the antitrust side, and a lot of what's interesting on the consumer protection side, took the authority from the commission level and did that same thing, deputized it. And the issue that presents is the following. We are now talking about, in addition to almost all of what the commission does, a lot of its most expensive endeavors. And what this does as a practical matter is remove commissioner oversight. You used to guarantee the benefit of to staff from the input of commissioners and also to the public to understand that, to make sure that commissioners knew how our resources and could help direct how our resources were being used. Now, commissioners generally let staff do their work. That's important. But we want to make sure, and we have a duty to the public to ensure that our resources are being used well. And I'm concerned that removing that oversight from the commission will add on to these other ways in which I've mentioned we are going to be doing our work less efficiently. It certainly removes oversight.
How would this actually get challenged in practice? If there's a company that is under investigation, but the investigation was initiated only by one commissioner, is that a lawful investigation? Can such an investigation use taxpayer resources?
It is lawful. The commission can choose to give away its authority to one particular commissioner. I don't mean a particular individual, by the way, just to one of the five. That is legal. There's no legal problem with that. I just think from a policy perspective, there's a reason the commission had never done this before. And I do think it removes commissioner oversight, and that is ultimately a bad thing because the commission is not supposed to be the CFPB, right? It's not supposed to be run solely by one person. It's supposed to be a commission.
But in practice, Commissioner, if I can just present a hypothetical to you.
Sure.
Could you go to staff and say, I'm a commissioner and I want you to launch an investigation of company X? Would the staff listen to you? Or does the staff only really recognize one commissioner as having that authority?
Well, I think it has long been the case that the chair ultimately directs the agency. So,
of course, yes.
And I think whether one other commissioner, I can't imagine staff proceeding on an investigation without also consulting with the chair.
I simply present this to try to illustrate the to me, the impossibility of this type of delegation, the highest. I'm sorry.
So I just want to be clear. Legally, I think it works. This has been something that we have done for years. My point is simply when you're talking about the biggest endeavors, the cases that require the most resources, resource that could be put to good use elsewhere. Right? This is what we're talking about, opportunity.
Right.
And also, you're dealing with the fact that I think Commissioner Insight is good, right? I want staff to be responsive. And even if they don't agree with every commissioner, to have answers to the questions, to have gone through the exercise of thinking through, counter arguments. I think that's an important dynamic. It's one of the things that has made the commission strong over the years. So I think commissioner oversight is a good thing. And I'm worried that for a lot of the high profile stuff, not just high profile in terms of news, but the costly stuff, the harder policy calls, we're moving away from commissioner oversight. So again, not a legal problem per se, but a policy problem.
I just want to suggest there may actually be a legal problem. I'm not sure that a commission that 3 commissioners on a 5-person commission can essentially delegate to one commissioner powers that belong to the entire commission. Otherwise, you are moving to just a single person commission, and I personally find it deeply troubling. It makes, I think it has a lot of serious consequences. But Commissioner, I can understand that being one of those sitting commissioners is very difficult for you to discuss that. So I will move on to another topic, which is privacy, which I think is where the FTC gets properly a lot of its current attention. And this is one of the most important issues in the American public right now. Tell us about privacy policy and what's going on at the FTC right now.
Sure. So the FTC has authority in 2 respects with regard to privacy. The first is that there are a few statutes that bear on privacy: the Children's Online Privacy Protection Act, the Fair Credit Reporting Act, that give us specific authority. And we use that authority on a fairly frequent basis, and I think to really good effect. The other thing is that we have used our residual FTC Act Consumer Protection Authority, Unfair and Deceptive Acts and Practices, over the past few decades to develop a privacy enforcement program. And by the way, it's not just privacy, it's also data security. And we've gotten court buy-in for this. And I think we've had a really positive effect in terms of spotting some practices that are bad, that are unfair or deceptive, and stopping them. And while the US does not have a kind of global umbrella, comprehensive, whatever word you want to use, privacy statute like they do, for instance, in Europe, I think our enforcement has actually been really meaningful. And there are a lot of big cases that we've brought in with good results that have gotten important companies under order. And I think that's been really good. Now, I think there are things that Congress may want to do that go further. But I do think, given the authority that we have, and even recognizing the fact that other jurisdictions have much more authority, I think the FTC has been a very effective privacy enforcer.
How do you see the efforts at the state level, such as in California, versus the federal level? Where do you see privacy law going? Are we going to have different privacy laws at the state and federal level, or do you see a scenario where there becomes a federal privacy law that overrides state laws?
So I do, what you're seeing is really every year, state after state after state is adopting some kind of privacy law. Some of them have some similarity, but there are also some big differences. My view is that this is kind of core interstate commerce, and that both consumers and businesses would be better off if we had one law. So I think on the consumer side, one of the things that to me, privacy is most about is the feeling that a lot of people have that there are data being collected from them, and they're not really sure how it's being used. And sometimes they're surprised when parties they don't recognize have data about them. So a lot of this has to do with a complex marketplace that has developed and the consumer understanding about that marketplace. To me, one of the things that this means is that you want to have consistent rules, right? You want consumers to best understand what's in and what's out, what people can do with their data and not. And unless we solve that consumer understanding problem, I think we're going to continue to see privacy worries. Take Europe, right? They adopted GDPR 3 years ago. And what you see is a lot of griping that people still feel like their privacy isn't protected. In my view, a lot of that has to do with understanding. And if you have a variety of different state laws, you lessen the ability for consumers to understand. If we all have kind of one consistent law, and by the way, think about like how we do checks in America and like the Uniform Commercial Code. There are many different areas of law where even if the average consumer isn't a lawyer, doesn't have a particular understanding, people have a general sense of how things are supposed to work. We can do that with a privacy law. And one of my worries with state laws is that they work in the opposite direction. You've got a bunch of different standards. The other problem, of course, is for businesses. And abiding by regulations, doing the necessary level of compliance work, that's a costly endeavor. And sometimes it's worth it. But the smaller you are and the more money you have to invest in compliance, which more laws means more compliance, the more problematic it is. And I worry that at a time when people are concerned about competition in digital markets, imposing too many different regulatory regimes will mean that smaller firms in particular will be spending a lot more money on lawyers and too little on engineers. And fundamentally, for growth and for meeting consumer need, for innovation, for competition, I want engineers, not lawyers.
And presumably large companies would better be able to afford a morass of regulations and wouldn't be.
Sure, right. This is a classic economy of scale. If you've got if you're just bigger and you've got more money, you can allocate more efficiently money to making sure that you abide by all those laws. That's harder for a startup, a lot harder.
Does the FTC have, in your view, sufficient statutory authority right now to address privacy issues, or is additional statutory authority from Congress going to be either necessary or at the very least helpful?
I think fundamentally, Congress needs to make these decisions. The big reason for that, in my mind, is that when you're talking about privacy, you're almost necessarily talking about trade-offs. Trade-offs with innovation, competition, and so forth. That doesn't mean those trade-offs aren't worth making, but those are fundamental policy judgments. And I think that's why we have a Congress to make those decisions. The FTC does have, as we talked about earlier, this ability to make consumer protection rules under the MAGMOS authority for unfair and deceptive acts and practices. So I think that there are privacy-related things we can do. But I think if you're talking about broad privacy reform, how we're going to govern consumer data in America, it's very clear to me that Congress is the place where those decisions need to be made, not by a vote of 3 or 4 or even 5 people at the Federal Trade Commission.
Let me just touch briefly on some activities that may be going on at a sister agency over at the Federal Communications Commission, which may be looking at network neutrality in the coming year or two. And one of the ways that they might look at network neutrality would be to declare certain services to be common carriage Title II issues. Can you explain how that would affect FTC jurisdiction on certain areas, including privacy?
Sure. So when something is a common carrier or a service is common carriage, we don't have jurisdiction to go after it. So the agency was founded at the time we had the Interstate Commerce Commission, which dealt with a lot of common carriers, and our jurisdiction carved that out. So once they classify something as a common carrier, there are problems that then presents. Now, I will say there was a case in the Ninth Circuit involving AT&T Mobility where the court did rule en banc that where the activity is not common carriage, we can deal with it. So we have that, which is helpful. And we would still be able to bring privacy cases, against, and data security cases against the Netflix, and Facebooks of the world. But since the Restoring Internet Freedom Order, right, which took down net neutrality, we have had, the ball has been passed back on ISP privacy. And we've done a 6B study, and we're still, that hasn't been released yet, but we've done a lot of work looking at the practices of ISPs with respect to privacy. And my sense of the world is that that's where the jurisdiction ought to be. You have an agency in the FTC that has decades of privacy enforcement experience. And I hope that's where it remains.
Justice Thomas, in a concurring opinion in a case, Biden v. Knight, earlier this year, sort of publicly ruminated on whether various internet platforms might in fact be common carriers. And a great many commentators on the left have also made the same ruminations. Have you seen, is there any discussion at the FTC or elsewhere about what these ruminations about whether certain internet companies are in fact common carriers, what that might do to FTC privacy jurisdiction?
So, we don't ultimately decide who is a common carrier and who is not. That's not our call. I think the question of whether platforms ought to be considered common carriers, what common carriage means as applied to speech, is a very active debate. In the academy, you see some of this in the courts on Capitol Hill. I think that it raises a lot of First Amendment issues. Any kind of speech regulation raises a lot of First Amendment issues. But we live in a world where you do see platforms, lots of them, dealing with the issue of how to moderate content. And you see, broadly speaking, two very different views on how they ought to do it. One side is sort of saying, take more stuff down. The other side is saying, leave more stuff up. So you don't have a social consensus on what we ought to do as a country. But I think because this is a big way that people speak and that people listen in our world, right? The media of communication are changing. I think this is a conversation that is just at its beginning. We're nowhere near the end of it.
Well, Commissioner, this has been a delightful conversation. I want to thank you so much for joining us here. I could go on probably forever, but I want to be respectful of your time. And I think everyone listening to you is grateful that you are, in fact, the commissioner at the FTC. You're very thoughtful and have brought a wide range of experience to your very considered opinions on a wide range of topics. So I want to thank you and look forward to hosting you again at the Hudson Institute before very long.
Well, Harold, you are always far too kind to me. I really appreciate the opportunity to be here with you. And thank you so much. And I look forward to being back at Hudson in the not too distant future.